Well, welcome to the second webinar on this very important subject of the changes coming up for every family trust in New Zealand. This webinar is brought to you by the Brainstorm Room, which aims to be New Zealand's most comprehensive help and advice website for small, medium and family-owned Kiwi businesses. I'm Jamie Tulloch, co-founder of the Brainstorm Room and managing director of E3 Business Accountants. E3 is the engine and the driving force behind the Brainstorm Room. So firstly, thank you for registering for this very important webinar. Because we had so many registrations for our first webinar just on Tuesday, we had to run a second one today. So what's so important about the legislation coming into effect on the 30th of January next year that we have to run nationwide webinars? If you're a trustee or a beneficiary, then you must understand what's happening to trusts. There's just no escaping from what the new legislation means. Time is running out to get your trust in order by the 30th of January 2021, just a few months away. Trusts will no longer be able to hide or conceal assets and just cruise along thinking their assets are safely secured behind a family trust wall of protection. So this trust webinar is chocker with real live examples of trustees and beneficiary situations and what they must do next. Okay, so let's talk briefly about how this webinar will work. As a webinar audience, you have two options. You can be a passive observer and treat it like watching TV. If you're not off in front of the TV, like sometimes I do, then you can watch a replay. We will send an email link out to the recording after this webinar, or you can get actively engaged and ask questions. To ask a question, just scroll down a little and you'll see an area to type your question. Because the large numbers engaged with this webinar, we anticipate a lot of questions rolling in, just as they were on Tuesday. But I will be putting these questions for Andrew during our Q&A session, so you can relate to real-world family situations. Andrew will do his best to answer them all during and at the end of the webinar. What he doesn't get to answer today, Andrew will follow up by email with you over the next few days. And to go one step further, Andrew has kindly offered to provide a free assessment of your personal trust situation. We have developed an online form for anyone wanting a free assessment. And I've got a copy of that here. Online, it looks a little bit like that. There's 2 or 3 pages to fill out, but we will send you a link to that after the webinar. And also after the webinar, you'll get a link to watch a replay of this so you can watch it at your leisure. Now, Andrew says that this assessment will take maybe 10 to 15 days. There may be many, so please be patient. So rather than have a monologue about the new legislation, I will ask Andrew some generic questions so you have an overview, and then we get straight into the questions, and then we have already that have been already sent in, and many coming from Tuesday's webinar. Andrew tells me there are an estimated 450,000 trusts in New Zealand. But no one knows for sure because there's no national trust register and therefore no official record. So why so many trusts, and what were the motivations to have a trust in the first place? So essentially, trusts were formed for both practical asset protection, but many were driven by emotional responses to family situations, real or imagined. So some of the typical reasons were, we don't like the chap our daughter married, so we want her grandchildren to inherit our wealth, not him. We want to protect our assets against business failure, or we want to hide my wealth from any future relationship partner I might fall for. And another typical one at the time, I don't like Michael Cullen raising the top personal tax rate to 39%, so I'm going to trade through a trust at 33%. Maybe the 39% tax regime is coming back. Will trust offer a tax benefit? Watch the space. Now, also, I want to be personally poor, so I qualify for a rest home subsidy. So, and another one was the fear of missing out. If I didn't have a trust, you might be missing out on something. So they were the motivations generally to have a family trust. So that's enough from me. Let's introduce Andrew. Andrew is a lawyer at Mortlock, McCormack, and Andrew has over 30 years' experience as a lawyer, and a large part of his practice relates to family trusts. Andrew was previously the chair of the property law section of the Law Society and from that position was appointed to the Justice Ministry's Trust Reference Group. Now, that group was established to review the work of the Law Commission, the Trustees Act 1956, and the recommendations from the Ministry. This appointment gave Andrew valuable insight into the government's thinking about the drivers and the expectations for law reform. Andrew offers clear and constructive advice to people who have trust and are uncertain about what to do with them. He has firm views about the future of trust. So, Andrew, thank you very much for committing so much time as our guest today and last Tuesday, and also your generosity to offer assessment for anyone in the audience today who completes the online assessment form. So, Andrew, here's your first question. So, tell me, what's the new Trust Act 2019 all about?
Well, Jamie, essentially, it's a catch-up of the last 60 years. As you mentioned in your intro, the old Act is 1956. And it simply ceased to be able to do the job properly. So the new Act is about restating and reforming the trust law that we have now. But it's important to remember that the new Act is not the end of the journey, because the new Act allows courts to develop the common law. And what that means is that as cases about trusts are litigated and precedents are set, the law will continue to evolve. So a lot of what the Act is about lifting the standard of trustee performance in New Zealand. We've developed some pretty bad habits over the last 60 odd years. So the new Act sort of puts a line in the sand about what's acceptable, what's going to be not acceptable. And it's going to require, because of that lifting of the standards, it's going to require a change of attitudes that trustees have towards their trust. It's going to change the relationship, I think, that trustees and beneficiaries will have. And I think ultimately, this Act is about driving down the number of trusts in New Zealand.
Okay, so what are the main things I need to know about the changes that are coming in January next year?
So there's two main things that I think everyone needs to know about the changes. And the first one is that there are going to be a new set of duties and obligations that all trustees of all trusts will have. That's in line with that lifting the game theory. The second major change is something that's called the disclosure regime, and that is new. It's going to give beneficiaries rights to information that they've never had before. This is brand new territory for trusts, and because of those rights, I think that the balance of power that exists in a trust between trustees holding on to the power, beneficiaries not really know what's going on, all of that's going to change. So it's going to also require a much more formal approach that people, trustees, need to have with their trusts. It's going to just, as I say, be part of that lifting of the game. It's not going to be business as usual, that's for sure.
Right, so this sounds like there's going to be more responsibility and liability on trustees. Just explain what heat will be put on trustees now that perhaps is not there at the moment.
Well, I think the main way that it's going to be evident are the new duties that are going to be imposed. So we have something called mandatory duties, and we have something called default duties that are written into the Act. Mandatory duties will apply to all trusts. They're not optional. Default duties will be apply to all trusts unless the trust deed says otherwise. So the mandatory duties, they're not a surprise. They're not complicated, but they are new. And one of the mandatory duties is you must read and know the trust deed. And that sounds sort of slightly an odd sort of thing to put into a piece of legislation about trust. But I think what it does is it underscores the lack of knowledge a lot of trustees have about the trust that they're administering. So that's really important. In addition to those duties, there are going to be really extensive record keeping and administrative requirements for running a trust. So the typical sort of trust documents scattered all over the office or the bedroom or the garage or wherever they might be is not going to sort of cut the mustard. What those duties are all going to mean in order for you to be able to show that you can discharge those duties is that you're going to have a much more thorough knowledge of what the purposes of the trust are, what the assets and liabilities are held by the trust, what the needs and circumstances of the beneficiaries are. And that's going to mean a process for administration is going to be quite formal.
Okay. Now, you mentioned before the disclosure regime. I've got a lot of questions that have come in over the last few days about the disclosure regime, and we'll cover those because there's lots of real life situations here that I'll ask you. But just briefly, just touch on the disclosure regime, because that seems to be the biggest fear and the biggest change that's coming.
Yep, and it is the biggest change, and it's probably the one that you need to fear the most. The purpose of the disclosure regime and why it's new, it's about, the Act says it's about the beneficiaries being able to enforce the trust. And what that simply means is that the beneficiaries can keep an eye on what the trustees are actually up to. So we've had this old situation under the old Act where beneficiaries had very limited and very few rights to know anything about the trust. If you think about it, that's a bit odd, because if I've named you as a beneficiary of my trust, but I haven't told you anything about the trust or even told you that you're a beneficiary, how do I know what you're doing with those trust assets? So that's why it's come into being, and it will be a challenge, I think, for a lot of people. It's important also to remember what I said before about courts continuing to make decisions about trusts. So because this regime is new, we don't know where the courts are going to take it, but I think it's fairly obvious from where the general direction of law is going is it's going to enhance beneficiary rights significantly. So if I could just perhaps talk about the two parts that disclosure comes in. It's a two-step sort of process. So the first step is that from the 30th of January next year, all trustees of all trusts must tell every beneficiary, and that's very wide, every beneficiary means every beneficiary, certain basic trust information. The basic trust information is basically, you are a beneficiary of the trust, these people are the trustees of the trust, these are the addresses of where the trustees live, and we'll tell you if there's any change of trustee, and if you want to, we can give you a copy of the trust deed. So that, we can give you a copy of the trust deed and any other trust information. So you're not at that point handing over the trust deed, you are inviting those people, the beneficiaries, if they want to see more, they can. Now, so that's basic trust information, and other trust information will be a much wider category of documents and resources about the trust. Principally, they will be financial statements or asset and liability statements or bank statements.
Okay, thank you, Andrew. So if there's 450,000 trusts or thereabouts in this country, whether it's 400 or 500 or 500,000, whatever, there's no national register, so no one knows. So does that mean that there's 400,000 trusts that need to be amended, or something has to happen between now and the end of January? Let's say I don't get round to it, I just do nothing.
Well, the short answer is yes. Every trust is going to have to respond to this. And I might add, this Act applies to, in legal speak, what are called express trusts. We're talking generally here about family trusts. Family trusts are a subset of express trusts, but those rules will apply to charitable trusts, they'll apply to whānau trusts. There's a raft of different type trust settings that this Act applies to, so it's not just about family trusts. So if you don't do anything at all, which is an option, but it's not a strategy I'd recommend, you're going to probably find yourself pretty much in breach from the 30th of January next year. And that's going to manifest itself probably because if you don't know what you're meant to be doing, you're not going to be able to discharge those duties that I talked about earlier. And so the failure to sort of engage with the Act and take positive steps, it's going to see, firstly, you breaching your obligations for disclosure. That will probably indicate that you're going to fall behind on your administration duties, and that will also mean that you can't make proper or informed decisions as a trustee. So it'll be a cascading effect.
Right. So I'm sitting here and I've got my trust deed and it's 20, 30 pages long, and it's a bit jargon-like, and I'm getting through it. And I get to the end, and I have to say, well, what questions do I need to ask myself, or what questions do I need to take to you as an advisor, or to my lawyer, or to my accountant? Say, I've read the trust deed. What am I meant to be asking myself before I take that next step, whatever that next step might be?
Sure. Well, look, the basic question I always come back to people when we're talking about a trust, for whatever reason, is why do you have a family trust? Why is this trust here? So you need to ask yourself, why do I have a family trust? Are the reasons that were relevant at the time the trust was set up, are they still valid? Are the circumstances that related to the need for the trust 10, 20, 30 years ago still the right reasons to have a trust? I think it's also really important to ask yourself, having listened to this and hopefully doing a bit more research, is do I have the ability to change the habits of a lifetime, and potentially the bad, or most usually the bad habits of a lifetime? You have to want to have your trust work under this new regime, and you actually want to be proactively engaged with it. If you're going to be sort of resisting the changes that are coming, then it's not going to end well for you. So once you've thought about that, as you mentioned, Jamie, the trust deeds are all in different format. There's no single form. You're probably going to need to get some help, some professional help from your lawyer and/or your accountant to help you on the next bit of this.
So if I want to just get rid of the trust, what should I do?
Well, probably the first thing you need to do is you need to read what the trust deed says about winding up of a trust. As I mentioned, not all trusts are the same. Some trust deeds allow you to wind it up early, some don't, obviously, and there'll be rules that apply to what happens to the trust and the assets of the trust when you wind them up. So you want to be really sure about what you're doing if you're going to wind up the trust, because there will be some follow-on consequences for that. Okay.
Now, we've had a lot of people join us since we started, so I'll just do a brief recap. We're doing a Q&A session with Andrew Logan, who's a partner from Mortlock, McCormack. He knows an awful lot about trust because he contributed to the current trust legislation that's coming into effect on the 30th of January next year. And the questions that we're asking, questions that we've accumulated over the last few days, in the last week, in fact, of people who have trust, know about the change in the legislation, but don't know what to do about it. So we're just going through these Q&As because they reflect real life, practical situations of families. So what are my options if I want to keep the trust? What should I do, Andrew?
Well, I think for everyone, whether you're keeping the trust or you're not keeping the trust, I think that the minimum that you want to do now is, there are two things probably, well, there's three things. The first thing is you need to get the trust deed out and you need to read it. And when I say the trust deed, you need to see the original, or at least a copy of the original signed and dated trust deed. It's probably a bit risky to look at something that's not signed or dated because it might not be what actually was signed. So read it and understand it. Understand who the beneficiaries are. Understand what the purposes of the trust are, because these are going to be really relevant. And we find that people have worked on an assumption. They were told 30 years ago something about the trust, and they've just acted on the advice or what they remember, not looking at the deed. The other thing you need to do to make a decision about retaining or keeping the trust is read the Trust Act. And I know that sounds like torture.
It does, surely.
But as someone who had some input into helping shape it, I think it's a reasonably plain English bit for a piece of legislation. It's not bad to read. And I think if you're going to take trust seriously, you need to understand what the Act is saying. So it's not a difficult read. I think Jane would probably want to go and watch Netflix, but I think it's one of those things you just need to sit down and plow your way through.
All right.
You can find that easily. Simply Google Trust Act 2019, and the first thing that usually pops up is the government's website, www.legislation.gov.nz. That's where all our acts and regulations are stored. There's no code or password. It's all free information. So find the Trust Act and actually read it.
All right. So we could send out a link with that address on as part of our follow-up to this. And for those who are watching, this is being recorded, and we'll send out a link for a replay after this webinar is finished. Now, here's a question that's come in. Our trust was formed about 20 years ago. Frankly, I can't remember what assets it owns, and I have no idea where the documents are. What should I do? How do I find them? Who do I ask?
That probably would hint to me that a trust and you are probably not good bedfellows and you shouldn't have it. If you can't find it, probably you'll have to think back through and possibly back through your lawyer as to who drafted it, who do you think might have drafted it, and make inquiries with the law firm to see if they've still got it. If you think it might own the house that you live in, with the assistance of a lawyer, you could get a land title search, and you can do what's called historical searches to see who did the conveyancing for you, and that might point to the law firm. If you think you've ever had any financial information because it's earned income at some point, the accountant that might have been involved with that might have the trust deed. So good luck.
Right. Now, Andrew, you mentioned the word breach before. How do we know we're in breach of the new legislation? What happens if we do breach it? Who knows? Who cares? How do we find out whether we've breached something or not? There's no master authority coming knocking on our door saying, Jamie, you've breached the new Trust Act. So just explain to me what breaches are and how do we know we've breached a law when we're not particularly familiar with it?
Sure. Well, the breaches are probably best described in terms of looking at the duties in the Act. And the Act sets out, as I say, those mandatory and default duties. There's probably about 20 odd duties. There's duty to do something. You must read the trust deed. You must act impartially. You must follow the terms of the trust deed and so forth. So if you look through those, you'll know that you are potentially in breach. One of the breaches is not to use trust assets for personal purposes, which is probably where lots of trustees will be in breach.
Yeah.
Who's going to enforce that? Well, it's probably going to be the beneficiaries. And why will they do that? Or how will they do that? They will do that because from January next year, they'll have a copy of the trust deed. They'll see what you see. They'll have copies of the financial information. They'll be asking about those assets. So the enforceability or the calling to account will come from the beneficiaries. If you continue on perhaps in the bad old ways of this is my trust and I'll do what I like, if that's your sort of modus operandi of the trust, you're probably in getting into slightly dangerous territory, I would have thought.
Okay. Now here's a not untypical question to come in. We have a family trust and one of our children married a partner who's turned out to be a bit shady. We really don't want him to share in the inheritance. How do we prevent this without a trust?
Without a trust? Well, with or without a trust, I think that question really is talking about relationship property rights rather than the trust. So the law about relationship property is a whole separate topic, obviously, but it's important to understand that a trust doesn't provide the ring fence that it used to in terms of sons and daughters-in-law. So I think for your dodgy son-in-law, what you're encouraging your daughter to do is take relationship property advice in terms of a Section 21 agreement, commonly known as a prenup. And she can enter into an agreement with the dodgy son-in-law to say, anything I get from mum and dad, irrespective of what I do with it, will always be my separate property. And whether that comes directly through the will or from the trust.
Just to clarify that question, it said married a partner. It didn't mention dodgy son-in-law, so it could be a dodgy daughter-in-law.
Could be. And of course, remember, that applies to people who are legally married or people who are in de facto relationships.
Right. Here's another one. Are there also changes to whānau trust or Māori freehold during this webinar?
Not during this webinar. In terms of what I said before about this Act applying to express trusts, so whānau trusts are come about through the Maori Land Court under the Te Ture Whenua Maori Act, and that's they are a form of trust, and the obligations of this act will apply to all of the trusts that are created under or through the Maori Land Court, and there are about 5 different varieties of those. But yeah, it applies to whānau trusts in the same way it applies to charitable trusts.
Right. My family trust owns shares in 3 companies I own and manage. We did this to protect the company's assets against worst case scenario. Will our trust lose its ability to protect our company assets?
Short answer is no. Nothing changes about the reasons for trusts. So all of the reasons that you mentioned in your intro and as that question talks about remain. Think about what's around it. So the legislation and the obligations of trustees and the rights of beneficiaries are the things that have changed, not the reasons for having a trust.
As a typical one, our children often badger us, asking what assets we have tucked away in our trust. Does the new legislation mean that we will have to declare everything to our children? I guess that comes to the disclosure regime, which you mentioned before.
Absolutely. So that's precisely on point as to where the disclosure regime is going to be a bit difficult for some people and some families. So absolutely, you have a proactive duty as trustees to make this disclosure. It's not about waiting for someone to come to you. You have to front foot it. And from next January, you will have to go to beneficiaries and say, this is who we are, this is what the trust is, this is where you feature in it, and this is what the trust has. I think that's why these changes, the disclosure regime, I think are going to be difficult, because you're going to create an awareness in terms of knowledge when you tell beneficiaries, and I think that awareness is going to create expectation, because as soon as you tell someone, by the way, you're a beneficiary of this trust, and by the way, this trust has got several $1 million worth of assets in it, a beneficiary is likely then to say, well, how can that help me?
Right. Okay. Here's another question, which is quite typical of the time. Many years ago, we took advice and formed a trust. So when we were means tested for the rest home subsidy, we would qualify as we had no personal wealth. Will all this now change?
Yes, it will. And it's probably not so much this new act. Probably the trigger for that change occurred back in October 2011, when gift duty was abolished. So those of you out there who have been on a gifting program with your trust will well remember the process you went through every year with your lawyer or your accountant, where you forgave $27,000 a year, 54 per couple, to reduce debt. So gift duty was abolished, and the reason for gift duty being abolished wasn't anything about an inefficient tax system. It was about the government's ability to look through trusts to get people to pay for their residential care ahead of the taxpayer if they had assets in trust to do so. And that's come about through something called the deprivation test.
Good answer. Thank you. If we wound up our trust, which owns the family home, who then takes ownership of our house? Would there be legal costs and maybe even conveyancing costs?
Certainly. So if you decide not to continue with the trust and it owns a family home, the next question is, well, which of the beneficiaries gets the house? Because it can only go to one of the beneficiaries. Assuming that mum and dad are named as the beneficiary of the trust, it can simply be distributed back to mum and dad. So it goes out of the trust, comes to mum and dad, it becomes mum and dad's personal property. So there's a decision, that a trust process to distribute the asset. There's a legal process to change ownership, and if that might involve a mortgage. There might be a mortgage that needs to be discharged that the trust held, and that's replaced with the new mortgage that mum and dad hold. And that triggers then thinking about things like, well, is your will up to date in terms of what that says about the fact that we've now got more assets in our estate now that we own a house. And that might also mean you've got to think about enduring powers of attorney as well, because they deal with your personal assets, not your trust assets.
Right. If the trustees act carelessly and make bum investments, what can the beneficiaries do under the old rules, and will they have greater powers under the new rules?
The consequences of getting it wrong as a trustee probably haven't changed, in the sense that the new act isn't imposing a new set of penalties. You make a bad decision, you get fined $100,000 or whatever. But what it's going to mean is that those decisions are going to, or those errors, mistakes, bum decisions are going to be discoverable by the beneficiaries. And so the more likely consequence will not be a fine per se, but will be a challenge to your ability to continue on as a trustee. And so there are cases that we're seeing, particularly in the High Court at the moment, where disaffected beneficiaries go to court and say, we don't think the trustees are doing the right job, or they've made mistakes, we want them removed. And the courts will do that. So you've got to think about the consequences of that. If you are the mum and dad trustees who have spent your life putting assets into a trust, and suddenly you are removed as trustees, that's quite a confronting position. But believe you me, that does happen within families here now.
Thank you, Andrew. If a couple separate, can they still both continue to be trustees and keep the trust going?
Yes, is the short answer. The merits of that will depend on the degree of civility, I suppose, between the separating couple. It's not uncommon that happens. I guess the question is, why would you want to do that? And it may be because of the nature of the assets that you hold, and it keeps you informed about what the other's doing with those assets. But I think it goes back to, you have to have very clear reasons for doing it, and you'd have to know that you have to act as trustees first and foremost, not as former spouses. So look, if you're disciplined and you've got a good relationship, it's entirely possible.
Right. Here's another one that's come in. There was a family trust for my children created from their grandmother's estate in 1989. My children's father, who is a trustee, tells them there is nothing left in the trust. How can they find out the truth?
Well, again, from January of next year, the beneficiaries can go to the trustee or the lawyers for the trustee and ask these questions. So you can look backwards. It's not just about what's available or what happened on the 30th of January next year. It's about what's been the history of this trust, and I guess principally, has there been anything dodgy going on by the trustees over the last 30 years? Have they been applying trust assets to themselves? Have they been making bad decisions? Have they lost assets? So I think what I would suggest is, don't wait till January. You would approach that trustee now and say, change is coming. We can either do it the easy way or the hard way. We can either wait and make it really formal, or you can engage with us now. And certainly, I'm encouraging clients now to think about what the exchange of information is going to look like. How are you going to do that? Doing it this side of Christmas might help save Christmas Day for some people. Otherwise, it might be quite a difficult Christmas dinner.
Here's a good one. I would like to know the process for closing a trust and the legal costs. Yeah, you answer that one, Andrew.
Yep. Well, a bit like how long's a piece of string. The process, as I might have mentioned before, is looking at the trust deed and understanding who the beneficiaries are and what rules the trust deed itself might say about how the distribution is to occur and who it can go to. Typically, depending on what's in the trust, of course, it can range anywhere from, say, $2,000 to $4,000. Would not be uncommon for dismembering a trust. That might also involve accounting advice if you have, say, the shares in the family business. So those are costs that are just there and probably unavoidable, because winding up the trust involves transferring the assets. You need to think about what the other side of that's going to look like in terms of who's going to hold them and what you put around that. I think you've got to weigh those costs against the risks going forward and the costs of administration going forward, because I do believe administrative costs will get higher.
Right. Now, here's a question about the formation of a new trust. If a potential settler of a new trust has no person or persons who can act as a trustee, and the family solicitor will no longer act as a trustee due to the new Act's more onerous requirements, how can that settler appoint a trustee? In other words, where do you find a trustee that's willing to take on all these responsibilities and liabilities if you think it's a good idea to now form a trust?
If I could answer that question, I think I would make a fortune for myself. It's a real dilemma that faces people. The new Act has certainly scared a lot of lawyers and accountants who have traditionally held those roles. So I think there will be a place for corporate trustee companies to take on that role. I would say though, and I always say to clients, who's an appropriate trustee to have, and it's always someone who knows you and that you have complete trust in. Trustees can be guided by lawyers and accountants in terms of what their obligations are, but it comes down to your trust and belief in them. If you generally can't find anyone who will come forward, you might want to think about, is the trust the right thing to do? Is it the right vehicle to hold assets or hold wealth to pass on to the people that you want to? Otherwise, you are probably going to have to look at the corporate trustees, and that's the public trust, guardian trust. There's numerous trustee companies out there who provide that at a cost.
Just back to the disclosure regime, if you've got unnamed beneficiaries or a class of beneficiaries, or you've got a charitable beneficiary, a charitable trust or a charitable group who are a beneficiary, how do you disclose to them the financial position of the trust? If one, if they're not born yet and they're just a class, and secondly, if they're a charitable organisation?
Well, you're going to have to find a way to do that. The Act is very clear that the disclosure regime is on every beneficiary, and that means every beneficiary. So some trustees will go through and name people by name. Otherwise, they more typically will say the children of the grandchildren of, and so forth, or charities involved in research. Now, research for cancer, for example. So where you can't identify who that charity is because it is as general as supporting research to cancer or a sporting group or whatever, you won't have to disclose to those people. But if you've named the New Zealand Cancer Society or St John's or the Salvation Army, you will have to disclose on them. And if you haven't named children, you will have to name them by name, but name them by class. You will have to identify and disclose on them. I might say in terms of the disclosure regime, it is what's called a presumptive regime, which means you have to do it unless there's a reason not to. The Act is very much in favour of making disclosure, so you can imagine that the rules around rebutting the presumption or not disclosing are very complicated. There are a number of factors that you will need to consider, and again, they're set out in the Act, and you can read them in section 53 if you're taking notes about what it is that you need to consider. But once you've considered that you don't want to hand the information on, you then have to get the court to basically sanction that approval. So it's a really complicated process to get through. So disclosure is encouraged. It's not to be discouraged. Right.
80 years, that's the life of a trust in its current format. I understand it's been extended to 125 years. So I don't think there's anyone around today that will see it out to the end. So why the jump from 80 to 125? And then to ask the question, if it's 18 years now, are all trusts, if they remain in existence, automatically extended to 125 years?
Well, the rationale for extending for 80 years to 125 is to probably reflect the fact that people are living longer, that generations of families live longer than the one before it. So back in the 1950s, probably the life expectancy was not as great as it is now. So that's really the rationale for it. You can expand 4 generations of a family through 125 years. Quite why you'd want to have a trust last so long is another issue, and of course that 125 years applies to family trusts. Charitable trusts will still carry on forever like they used to. So that's why it's there. Will it apply to your trust? The answer to that is if you have a clause in your trust deed that the trust triggers on an earlier date than 125 years, then the terms of your earlier trigger date will apply. If the trust doesn't have a trigger date, then 125 years will apply. So again, you need to check your trust deed and see what it says about the end of trusts.
Right, thank you. Another question, you briefly covered it before, but probably could expand on it. Does this new law also apply to charitable trusts?
Yes, it does. Yeah. So the obligations, because I mentioned before about express trusts, and there was an attempt to try and define what a trust is, and it was too difficult. So we looked at what all the different trust arrangements were. So anytime someone is holding assets on behalf of someone else, that's basically what this will apply to. So charitable trusts are an example of those.
Right. Now, someone was watching the Tuesday webinar on the same subject, and I've sent this question in. It might be the subject for your next webinar, Andrew. This excellent seminar is designed for trustees to understand their responsibilities. Question, do you intend to run a similar education webinar for beneficiaries so they understand what they may ask for? So maybe there's some beneficiaries watching today.
Well, I think it's a really good question, because I think, as I mentioned before, this new regime that we're in, giving new rights, are all untested. And so there will be some requirements on beneficiaries to conduct themselves properly as well. It won't just be necessarily open season on trustees and it's all about the beneficiaries, but the general theme of that is the law is moving in favour, and this act certainly creates that beneficiary rights. It's about, and if you think about why do we have that regime, as I mentioned before, it's about beneficiaries knowing what's in it, what's been created in their name, because I guess it goes back to the rush of trust that we had and the love affair people had. They didn't really think about the wider group of beneficiaries. Most mum and dads thought about themselves as beneficiaries, but not thinking in creating the trust, they were creating rights for other people. And what the courts are typically saying is that if you've appointed or named someone by name or by class or by description as a beneficiary, you must have intended at some point that there could have been even an outside chance that they were going to get something. So their rights need to be protected. So that's really what has led to all of this. So the short answer, I should have said, I'd be keen to have a session for beneficiaries. Let's wait to see how some of the court decisions go, and that might be a more informative discussion.
So that might be a year or so away.
Yeah, might be a few years away, yep.
Right. We have an intellectually disabled child who cannot manage their own affairs. Can that child be named as the only beneficiary of our trust?
Yes, you could. It would be possibly unwise to just have one beneficiary of a trust, because if something happened to that beneficiary, you'd have to have a provision for where the trust goes afterwards. But trusts do have a protective purpose, and very often trusts are used in that situation. It doesn't have to be the only way of dealing with children who through adulthood might need protection from themselves and for themselves. You can set up trusts through a will where you provide what's called a life interest to someone who might have some difficulties with either the intellectual or physically being able to manage and look after themselves as adults. So trust is a way of doing that. If you were thinking you didn't want anyone else involved because of all the rules you've got here, then you might want to be thinking about what your wills look like and making a much more detailed provision in your will for those for children like the one you've just mentioned.
Right. Now, a couple of questions about the multi-land trust. Are these new laws also relevant? And are whānau trusts under the same act? You did talk about it before, but there's a couple of questions rolling in about this.
Yep. So certainly yes. Any act created under the Te Ture Whenua Māori Act will apply. These rules will apply to those trusts.
Okay. Now, if you have a trust and it owns the family home, but there's a mortgage involved, and you decide that it's no longer relevant to have that trust, or it's no longer pertinent to have that trust, there's obviously going to be a change of ownership, and that can impact on the mortgage because the mortgage is registered over the house, which is owned by the family trust or the legal owners of the trustees. How do you approach the bank? What do you know what the bank's view will be on unwinding a trust and keeping the mortgage intact?
Banks are always happy as long as they've got security, so they won't care. But the process will be is with that change of ownership, yes, getting a discharge of that mortgage and getting a new mortgage. That usually doesn't involve breaking any of the loan contracts that sit under the mortgage. So it's about the security, which is what a mortgage is. It's the charge over the land. So it's usually quite a simple process. There's no major drama in it, and banks are pretty familiar with the process. So there's obviously cost involved, but it's certainly not an inhibitor to winding up a trust and reorganising your finances and your security.
Here's a curly one. If you could not find the trust deed, you believe the family home is owned by the trust. How do you dissolve that trust if you can't find the original documentation?
Oh, it is a curly one. The answer is probably you will need the assistance of the High Court for that. You'll probably need to get some type of declaration out of the court around what the trust might have been or what it was. So you'll need to sort of create it in order to get rid of it. That's, I think, the short answer to the question. It will be quite an expensive exercise for you, in the tens and possibly tens of thousands of dollars, depending on how much information you can get. So yeah, you can't wind up something that you don't know what it looks like, because the rules for winding up are contained in the trust deed.
Will there be any benefits left to have a trust? The asset protection and building a fire break around the assets that you have, is it now so complicated and so much disclosure that trusts are almost redundant, or will there still be a role for family trusts in the future?
There certainly will be. I mean, I think the discussion that we have had this morning is about what's new in terms of the Trust Act. So what's new are these new rules and duties and disclosure. You're going to have to weigh those up against the reasons for having a trust. So the reasons are still valid. Asset protection, perfectly a valid reason for having a trust. The example we talked about before about children who might need the protective benefit of a trust when you're not here. Those are good reasons. Reasons for rest home subsidies, no longer good reasons for having a trust. Tax is another reason where you mentioned again in your intro about changes of tax rates. Trusts do provide the ability to split and spread income and reduce someone's potential personal tax liability. But if you want to get the advantages of those, you've got to weigh that against the disadvantages and some of the issues that we've been talking about this morning. So trusts can't do all the things that they used to do for all the people all at the same time. And that question about is the trust reason, or are there reasons for having a trust? Absolutely there are, but they will fit your personal circumstances, and you've got to have a trade-off between the pros and cons of keeping a trust. I might say people get very, very worked up about tax and not paying or rather reducing their tax liability. If you're singularly focused on trust, then you're going to have to accept that there's a lot of other information that is going to have to be disclosed. And if you're focused on tax for trust, it probably means that you've got more complicated assets in a trust. And so that's the trade-off. What do you want? Do you want a simple life where your business is kept to you? Or do you want to pay more tax, but but not not have to disclose. It's a simply a trade-off game.
I have a question here from a Auckland registrant talking about their assets. They have a business that's contained in a building that they own. They have a batch on Waiheke, it's very nice, and a boat and some shares in various other companies and some on the share market. They also have several finance companies involved in their structure. They're saying that seems to be a lot of unwinding. Who will actually take ownership of all those assets if they decide that the dissolving of the trust or the winding up of the trust is now prudent? Where do all those assets end up?
Well, again, the trust deed will direct you as to where those assets go, because the trust deed has the formula for what happens on a wind up or distribution of the trust. I guess the comment about it sounding complicated, it goes back to why do you have a trust? What are your reasons for the trust? And are those reasons valid? Those basic questions that I keep hammering home to clients. So, where the assets go, probably back to mum and dad, if mum and dad have put the assets into the trust, but not necessarily. And it is an opportunity for people perhaps to bring forward some estate planning to help children or other members of the family.
Okay, another question here. What's been the driving force? I mean, going back to square one, what was the driving force on the government? Why did the government initiate this change? And what does the government get out of it? What was wrong with it all before? So much work has gone in, new legislation has been passed. It's all changing on the 30th of January. What's the big picture? What's the underlying motive for the government to make these changes?
I think, as I mentioned before, the old Act wasn't working in terms of the numbers of trusts. The old Act never envisaged the number of trusts that we'd have in New Zealand. So what the old Act did do is cause problems behind some of the social policy objectives of other bits of legislation. So as an example, relationship property. We have something here called the Property Relationships Act. It's the old Matrimonial Property Act. And that has as its objective a simple 50-50 division, no fault, no blame divorce when couples or de facto couples separate. Now, when you put assets into a trust, they're no longer personal property or personal assets, they're trust assets. That's the whole point of the trust. But what it meant was that with the number of divorces that were happening, every divorce or separation generally involved a trust. And so the purposes of that act, the Property Relationships Act, were frustrated by the presence of the trust. So there's a social policy behind that. Similarly with rest home care, the residential care scheme, which is administered by the Ministry of Social Development, was to support people who could not afford rest home care. As the population has got older, as the taxpayer base has shrunk, the fact that you or I could sit and go to MSD and say, we have no assets, but to one side, we've got a trust that might have $10 million worth of assets in it. From a social policy point of view, is it right that the taxpayer of New Zealand is being asked to pay for you or me and give us rest home care when actually we're connected to a trust that's got a whole raft of assets in it that could easily do it? So those are probably two big drivers as to what's in it. And I guess the tax policy has changed a lot to make personal tax on a more level playing field, so that people with trusts didn't get advantages over taxpayers who didn't have trusts. So it's not. You might say, well, what's the government getting out of it? Probably a bit more tax, but it's not that simple, that binary. It's about having to adapt. Laws were having to adapt around trust because trust was such a force in the New Zealand landscape.
This is quite a complex one, so I'll summarise it as best I can. It seems to be that it's a blended family, and by default, some of the blended family, the good people and the not so good people, have ended up being beneficiaries as a result of the class of beneficiaries included. What process can the trustees go through to remove beneficiaries that they no longer think are appropriate to be beneficiaries?
Well, probably in that blended family situation, it goes back to the basic thing of reading the trust deed and just making sure that you are right in working out. Often, for example, blended families, you might regard people as your children informally, but perhaps not legally, and the trust deed might say, my children will be natural born or adopted, and the process of legal adoption makes those children yours. But my children, natural born or adopted, won't include your new partner's children. So just have a check to see, from the trust deed, what does it say? If they are in there and you don't want them there, then again, back to the trust deed about who can remove beneficiaries. Not all trust deeds allow beneficiaries to be removed. Depends how old the trust deed is. The older the trust deed, probably the more rigid and inflexible it is. Since about 2000, trust deeds are a bit more flexible. So have a look at it, and it will describe the process. And most likely you can remove them without cause. So you can simply say, I don't want you to be a beneficiary anymore, and you can do it. You still have to have a process to go through that and a justification for it, but you can remove them that way.
You said before about Christmas dinners. I think there's going to be some very interesting discussions around the Christmas dinner table this year.
Which is why I say to trustees, you want a front foot. If you're keeping the trust, you don't want to surprise people. So you want to engage with the beneficiaries sooner. If you're not keeping the trust, you need to act, and you need to act now, basically, to wind the trust up before we get too far into next year, and particularly before the end of the financial year.
With my experience, a lot of trustees are amateurs or family people who are not professionals, are not experienced at being a trustee, and may not even be aware of their existing liabilities and responsibilities as a trustee. And now we're getting in an area of enhanced or increased exposure of trustees. We're also thinking about the diplomacy skills now going to be required by trustees. Have you, a little bit off subject here, but how do you introduce your concern as a trustee to your beneficiaries? Do you go through a wee bit of a facade of getting a letter from your lawyer and you sharing that and saying, sorry, beneficiary, sorry, children, look, I've got this from our legal firm. We do need to have to deal with it. I'm a trustee of your trust and your mum is a trustee, or whatever it may be. And we now have to talk about this quite curly subject. Mm-hmm. Is that a diplomatic way to approach beneficiaries with this news?
There'll always be a diplomatic way to approach beneficiaries. I think it's an issue that lawyers are grappling with. Anyone involved in advising trusts, like lawyers and accountants, no one has the magic answer to this. Various legal commentators have produced for lawyers sort of suggested letters or ways of approaching, but I think you just have to simply, as I say, front foot it and probably a discussion first to say, look, the law has changed with this new act.
We now have to declare that we're not really millionaires.
Well, yeah, just so you know, yeah, mum and dad are the trustees. We set this trust up, and these are the reasons why we set it up. I think that's the conversation that you have. You've either set it up because, look, we had business risk and we were trying to save the house and the batch and Wanaka and so forth for your benefit. So we've done this for the benefit of the family, because benefiting us helps you. If that's your reason for doing the trust. We've set this trust up. You might have to be a bit more diplomatic if we set this trust up because we didn't like our son-in-law or our daughter-in-law or their partners or whatever. You're going to, I think genuinely most mum and dads are motivated to do what's right for themselves. And of course, if you've got children, you want to do, all of us want to protect our children from all the bad things that can happen in life. So I think the motivation is always there. It will be the delivery, I think, as you say, of how you do it. I think a lawyer's letter in some circumstances will be appropriate, but again, this is your family that we're talking about. These are you put the assets into the trust. These are your children. So I think you have to have that discussion and say, look, we're not expert trustees, as you say, and most New Zealanders aren't. So we're going to go and get some advice now, just to make sure that we're all clear of the rules, that we're clear of what our responsibilities are. We want to make sure that you know what your rights are, and have that sort of type of open discussion. Won't always work for all families, but it's a good way to start, and it's a good way to demonstrate your genuineness about embracing the change.
All right. Thank you, Andrew. Look, we're going to finish in a couple of minutes. We said that this webinar would last about an hour, and we're just over an hour now. There's so many questions. We could spend another hour here. So just a little bit of housekeeping before you all leave. Andrew has offered to do a free assessment on request, and there's a form that we will send to you if you've registered for this webinar. Whether you've got to watch it or not, you will receive a link so you can complete this form, and it will go off to Andrew, and he'll come back with some high-level general advice of what he thinks you should do next. Secondly, the link that we send out will also be a recording, so you can come and watch this webinar at your leisure. You can either choose to watch it, or you can sit up in bed and watch Netflix. I'll let you choose, but if you've got a trust, you probably should put some effort into this. And we'll also send a link to that very exciting document that Andrew introduced, that you can read the legislation yourself. Good luck. But Andrew said it's actually written in quite good lay language. I've had a look at it, and I thought I got through it okay. So therefore, I think it's going to be pretty digestible. And Andrew will finish off with a couple of minutes of just the key takeaways. What's the big stuff that you've got to do if you're a trustee or a beneficiary? What have you got to do over the next few weeks? Andrew will summarise what's the big stuff that's happening with trusts, and then we'll wrap it up from there. Over to you, Andrew.
Right. Well, hopefully I've repeated this message through the talk quite a few times. Read the trustee. The first thing you must do is understand what it is that you're the trustees of. That is just so important. So informing yourself, and as Jamie has mentioned, reading the Act, and I really do encourage that. The next thing to do is having understood what it is that you have and what the parameters of that are. What do you want to do next? And I think the decision will be you either will keep the trust, and in doing so, you will accept and embrace what the Act is requiring you now to do as trustees, or you will make a conscious decision not to continue with the trust. I think it needs to be one or the other. It's not going to just let it drift, because if you let it drift, you will let it drift in the bad old days. So this is changing behaviours, changing habits. So read the trust deed, make a decision. Am I going to keep this trust, and do I accept what's coming under the new law, or do I not accept the trust and I want to get rid of it? After that, you probably need to get all of that road tested with some professional advice, because I think it would be very risky to, on the back of this talk and just your own sort of the marbo of it, make a call. I think you do need to have that debate with your lawyer or your accountant about what's next. And then you need to plan for what's next, either the keeping or the letting go of the trust. And those will all have consequences, as we've been talking about. As a simple message to people who are stuck in terms of, I really don't know what to do, whether to keep, because I'm convinced some ways there are some benefits and I can see some negatives. What do I do? And I just want to put my head in the sand, which is a natural reaction. Think about how important control is for you. You are likely to be the only generation who has actually put assets into the trust. Of all the people who are beneficiaries of the trust, usually it's only mum and dad who have seeded the assets with the house, the batch, the investment portfolios, the shares, whatever it is. And every other beneficiary has taken from that. So you are about to enter territory where you will lose control because of beneficiary awareness and beneficiary rights. So if you don't want to go down that path, then a trust is not the way for you. If you don't mind going down that path, then a trust is a way for you. So the simple thing is control. How much importance does control of assets have for you? Because a trust will not give you that. Hopefully that's a simple way to conclude.
But we've just been watching all the chats coming in and the questions coming in. There's dozens and dozens of questions. So there's a lot of homework for us to do. We want to get back to everybody who's loaded a question in. It will take a few days, but there's some excellent questions being asked, and we want to actually try and ask and answer every one of those personally. That's a big load on Andrew's shoulder, which he's got a whole firm geared up to help you. And as Andrew has said, there's a lot of requirements and trusts to have accounting done and trust tax done. Now, we at E3 Business Accountants handle an awful lot of trusts, so we understand the accounting requirements and we understand the tax requirements. So if you need accounting or tax help with your family trust, send me an email and just give me a little bit of background, and I can come back with how we can help. But please do complete the online assessment, which we'll send out quickly. That goes to Andrew, and he'll give you some overview. So Andrew, look, thank you very much for your help and advice. By the responses coming in, you have answered an awful lot of questions and given some clarity, so something on the surface which appears quite complex. So thank you very much for your time today. Thank you for doing the assessment sometime in the future. And over and out. Thank you very much, Andrew.
Thank you.